Hello, everyone. Welcome to this webinar, Infojustice, where we're going to talk about the use of IT communications in the judicial experiences in Italy, in London, in United States, specifically in Florida, and here in Venezuela. Uh, this special webinar is part of the program of the postgraduate area of the Central University of Venezuela that wants to embrace everybody to study and other languages because that's a requirement for getting to the programs that the Central University of Venezuela offers in order to have a broader research. For also, we are talking about uh, English judicial system, and also Italian judicial systems and Venezuelan judicial system, because today this is English language day. So we're celebrating this day, speaking in English and speaking about or talking about e-justice that we call Infojustice, just to give a different name, but it's the same situation that with what we want to talk about. This webinar will be held in two blocks or two phases. The first block or the first phase, we're going to talk about written digital proceedings or procedural acts. And the second block, the second phase, we will be talking about oral digital proceeding or oral digital procedural acts. Uh, to start this webinar, we have, I am pleased to welcome Gerardo Sadra, who is a bilingual attorney licensed to practice in both Florida and Venezuela, bringing over two decades of extensive legal and real estate experience to our panel. Currently serving as a senior partner at Sadra Law Firm in Miami, he specializes in immigration law, expertly handling business visas, asylum, and deportation defense. Prior to this, he successfully managed a law firm in Venezuela focused on civil and commercial transactions. Gerardo holds a Juris Doctor from St. Thomas University, an LLM in International Law from Stetson University, and dual Venezuelan law degrees. He is also a licensed Florida realtor and speaks native English and Spanish, as well as conversational French. Also joining us today is Alberto Lama, who is an esteemed Italian litigation lawyer at Alture Legal, admitted to practice before the Italian superior courts. He's an expert in handling complex civil and commercial disputes, advising clients at every stage of litigation. His impressive practice includes cross border matters before Italian courts, as well as proceedings in other jurisdictions, in tight coordination with trusted local counsel. His primary focus lies in commercial, corporate, and civil matters. Today, Alberto will be sharing his unique and valuable insights on the e-justice experience in Italy and also in England. We have a fantastic agenda ahead of us. Gerardo, Alberto, the digital floor is yours. To start, I would like to say, to give our audience or the people who is going to listen to us later by YouTube some definitions or some glossary. I would like to tell them um, how what are the terms that we are going to use when we talk about demandas, procesos, procedimientos, jurisdicción, competencias, expediente y audiencias. So, to start, uh, when we talk about uh, demanda, so the petition we present before the court, how do we call it in USA and in London? Gerardo, could you please just some words? I mean, demanda, proceso, expediente, and audiencia. Those four phrases. How do you call
Yeah,
them
sure.
in your experience in the United States?
Well, here, generally you can call, a demand, you can call it your complaint. Uh, Hearing, you can call, audiencia. What is the other one that you mentioned?
Expediente,
File. We call it, file here. Um, Pretty much those are, the basic terms that we use in court.
Okay, thank you very much, Alberto. In your experience in your studies in UK, how do you call them? A summon, a citation, o la citazione in Italia, la
Sure.
notifica. Como, how do you call it in London?
In London, it would be claim or summons to appear for citazione o mandato di comparizione, service or notification for notifica, and for the file, what would be the docket in America, it would be court file or case record in England. And in Italy it would be il fascicolo del caso.
Thank you very much, Alberto and Gerardo, for this glossary, for this introduction. So let's get into the area that we're going to talk about today. If you receive today as a lawyer and you pass the bar examination in the USA, Gerardo, and you have your first case, what do you need to practice as a lawyer there? Do you need a car or public transportation? Because you have to go. There's no other way to watch a case record, a docket, or you need perhaps just a phone and an internet connection because you can watch all the judicial file, all the court record, all the docket by your phone or by your computer. What is your area of practice there in Florida, and what is your experience?
Well, before anything here in US, you need to have, insurance. You need to carry insurance before you start, receiving or represent any client. Especially, you need to have a malpractice insurance. Something happened, error or omission, you need to be, insured. After that, you need to register, maybe in the civil court if you're practicing civil. Also you need to be registered in the immigration court. You need to be assigned after you register yourself in those court. Then you will have a login. Most of the hearing in this moment they are held by webex, by internet, because most of those hearings take like a couple minutes. Sometimes, well, the actual hearing is just 10 or 10 minutes to the top. Those introductors hearing like a master, like a preliminary matters that you can attend. However, when you have like a to litigate or to have final hearings in immigration cases, you need to present yourself in front of the judge. Some judges prefer to be in person. Everything is going to depend the judge that you get assigned for the case.
Okay, but in your experience, you need a printer, you need paper right now to work as a litigator, as an attorney there in the United States.
Well,
The docket, the record, the court record are in paper.
no, most of the cases at this moment is just digital. You just create the PDF. Also, you can sign the PDF here. In US we put it just slash s/slash and your name, and that means sign it. Or you can use a platform as a we use here DocuWise. What is any platform in which you can say you can sign, and you don't need paper. We submit the record through the docket to the court, and that's it. And you file it, and the court is gonna assign a number, page, and the time that you are filing.
And for your identification, your ID, do you have a e-sign that you have to buy a certificate from a specific company that is authorized by the state to sell those e-sign system, or you can use any e-sign system? You can use your e-signature from any company. Doesn't matter. It doesn't need a special permit
No,
to
here,
give you.
here in Florida, you don't need like a company. You can do it yourself. You can sign just your name because you are using your login and your password to submit in, any file, complaint, or any motion is gonna be submitted, through your username. At the end, is gonna appear, I'm only, registered, attorney are allowed, to file, in those court. Of course, you can use, private companies like what is the name? The biggest one, Adobe. That's one that we use in the past. Also, we use something called, My Case, which is a platform that we use in the office because my office, I will say, is 100%, electronically. We storage all the information in servers. We don't use paper anymore.
Okay, thank you very much.
You're
And
welcome.
thank you. Alberto, in Italy, because that's your everyday experience, but also in London or whatever in other cities from UK that you have experienced, uh, how is the system? Do you need also, I mean, first in Italy and then in UK, do you need paper? You have to file all your petitions, your claims in papers and hand sign, or you can do it everything by a computer or by a phone?
Let's say that in Italy, the transition to digitalized files started 20 years ago, and it's been taking the place of the paper filings over time. And since about 8 years ago, it is mandatory in civil courts to file everything digitally. So almost nothing is filed in paper now. They've constantly improved the system over time because when it started, it had some faults here and there. I mean, when we started in 2007, the first experiences, you could only check the status of the file, what was happening in the case. You couldn't file anything. And then little by little, they implemented the filing stages. And then, roughly 8 years ago, they made it mandatory for every party to file everything digitally. So everything is online on a specific portal, which you can access using different programs. Usually, what happens is that every lawyers association that we have in the major cities where the courts are, they have an agreement with a specific company that provides the program. So there are like various programs. The functions are similar among all of them, and usually the program stores on your computer or in the cloud recently also all of your files, and you can always access them from everywhere at any time, really. Uh, what happens is that often they do upgrades to the software, and so you might not be able to do filings at a certain time, like for one day or a few hours in a day. So one must always be very conscious of what happens and when they are implementing upgrades to the system, because if you have a filing that is on deadline and you don't realize that you're not going to be able to use it, it can be dangerous missing a deadline. So definitely everything is digitalized in Italy. We have a more complex system for checking identity of the lawyer and signing the documents. It's not as straightforward and user friendly as in America, as Gerardo said. Basically, in Italy, we have to get a specific USB token, which is issued by the Lawyers Association in connection with some companies, and that's a digital signature. So we have a pin, and that's tied to our identity. You cannot even send anyone to pick it up when they give it to you. You have to be there personally and to check that it's you picking it up personally. And also, the filings actually happen through certified email, which only Italy has, which is a specific kind of email with the highest level of security and certification of who's sending the email and if the recipient receives it. So we have quite a strong authentication system, and we use this to sign the original files that we file in court. Not all the attachments, but the filings, the motions, the petitions, the requests, they're all signed digitally. In England, it is similarly very much digitalized, the system. I think paper still has quite some space, particularly because in England it happens very often that in civil and commercial litigation, the case file is very big. It contains a lot of documents, So often the lawyers prefer taking the printed versions to court so that the judges already have them at their disposal. Whereas in Italy, this is actually almost forbidden, not expressly, but substantially. And in England, there is no unified system for filing. It depends on the court you're filing with. So the systems differ a bit, but they're generally based on online sign in with login and password, basically. There is no digital signature per se, like we have in Italy. It's a bit more similar to the American system. But as I said, I think that the peculiarity is that it differs from court to court, so depending on the level of the court, basically.
Thank you very much. And Gerardo, you have e-record or yes, an online record, a case or record case record or docket. And what do you see there? If you have you had criminal experience? I mean, if you have your in your area of practice that you said is migration, but you have there maybe a picture of some injury of some minors. All those pictures can be seen online. I mean, for the parties, it's okay for their lawyers, but is it a public record? Like, is in Venezuela the records not criminal ones, but the civil ones? You can go and ask for the record in paper and watch it, and also to copy. Uh, when it changed to digital environments, is in your experience in Florida, in your area of practice, who can watch the record and what is in the record in your area, and if you know in criminal practice?
In general, record, are public. Civil proceeding and criminal matter are public. You can log in, you can search, in the database. However, when you have, sensitive records like minors or social security, you label those records, and the judge or the court is gonna put it like a blank space or something that protect those information. But if you go, to Google, search, I don't know, Miami-Dade. That's the county that we practice, and put, criminal matter, you're gonna see, the complaint and what happened, police report. Those are public records. Also in civil matter, also are public. However, immigration, which is the area that I practice more here in U.S., the immigration record, are sealed. Only the parties are allowed to see it. They are not, for the public. You need to have a user to get access. If you are part of the record, you can see everything. Even sealed record can be seen by any of the party if you request it to the judge. Here, you have, the principle of, publicity, in which, all the parties are allowed, and the community, the public are allowed, to see, civil and criminal matter. However, some of the sections, when you're dealing with a minor, or you're dealing, with something, like a matter of security here, the government security here in U.S., or something, or protecting information like a financial statement, social security, account number. Those information will be, protected by the court. Also, attorneys, can ask to the court and the judge, to protect those records.
Okay, thank you. And the same for you, Alberto, in Italy and in UK. How is the situation? Who can watch the digital record or the in your area of practice and in criminal practice if you have the experience?
It's completely different from the situation that Gerardo illustrated, because in Italy, no one, no, I mean, even the parties don't have access to the actual case file. Only the lawyers can directly access it. If the parties actually know the number of the case and the name of the judge, they can access the public information, which is accessible through a specific portal on the internet. but you don't see anything. You don't see the name of the parties, you don't see the name of the lawyers, you don't see anything but the name of the judge, the date of the hearings, and a summary of what happened. But it's just a one liner for any event, like something was filed, but it doesn't say what. And so it's just really, really super basic information. And this is for any case in the civil space. And in the criminal space, they just started actually digitalizing the system, and it's not working. So they've reverted to paper filings because it wasn't working. They just started the digitalization in the criminal sector. And in England, similarly, it's only the judgments are public, and not immediately. It takes some time for them to be published, and I believe not from all courts. So also there, it's not that public, the information concerning the proceedings at all. It's completely different from the American experience, I would say.
Alberto, and you think that it's because of you have data protection laws before data protection laws in Europe when you have a paper records, everybody can watch them. They were public or no? It's not
No.
it's not because of the digitalization.
No, no, no. It's always been like that. Even when they were paper based, no one would be able to see the files, to access the files, unless they had a specific interest in the file, but not some general access. You wouldn't have it because they've always been considered very confidential information. Those of case court proceedings, so they've never been public really.
Okay, here in Venezuela, we doesn't have a special data protection law, as I think the USA doesn't have it, except by California. I think they have a data protection law, but I think in Florida you don't have it. Gerardo will say that. But here we have a binding decision from a constitutional hall or division of the Supreme Tribunal of Justice from Venezuela from 2011 that says that, that established the data protection regime here, but doesn't apply. Nobody applies it, but it exists, but nobody uses it. So all the, the sentence, the decisions are public. The records in papers are public according to the law, are public, but depending of the area of practice, you can access or not. Uh, Perhaps in civil or commercial areas, you can watch. Everybody can watch the files. Not in criminal cases, and in labor and child and teenagers and minors areas. It depends on the guardian of the office of the records, but according to the law, they are public. But so we don't have like this for prohibition to access to the to those records. It means that anybody can watch, as Gerardo said, as happens in USA, account numbers, bank situations, ID, all the ID informations, um, all the testimonies, the declarations in the docket, and it present some problems because of what can be done with that information. It doesn't have, it doesn't know about somebody that have suffered something because of the misuse of his information taken by from court records, but it could happen. Gerardo, there, I think you don't have any data protection
No, we do.
regulation or law.
No, no, we do, data protection here in US. I think it is most of the state have some data protection, we have some limited. As I stated previously, I said that some of the record, can be sealed, or can be, covered with something, they put it like a blank space. like a driver's license, maybe the address. However, everything here in US is is open to the public, unless it's something like a minor, something like a really confidential, trade secret, immigration, because immigration record are covered or sealed for the public. But for the rest, we have really strict data protection also. We're not allowed to soliciting here in US. We're not allowed to, if asking for some information to a private person, we have some kind of restriction. In civil matter, before you request a record, you need to ask to depend of the case, also or the matter. Sometimes you need to request some permission by the court. But we have some
Okay.
kind of protection, not like Europe, however, because everything here is public. You just Google and you're gonna find, where I live, my house, when I bought my house, where is my office, how much I pay for my office. That's a public record here in US.
Okay. Thank you. And about the communication acts during the trial or during the all the process from beginning to the end, the first time that somebody is going to be informed that there is a process against this person have to be done in paper in his hand and he has to sign, or the first time somebody is going to be receive a notification, a citation, a summon or service, uh, could be online in let's start with United States.
Well, depends. If we're talking about civil matter, you need to be served by a summons. When you file a complaint, the complaint is submitted by the court. Then the court you're gonna ask or issue a summons. Then you're gonna hire like a private person or company to summon or to serve the summon on the person. If the person sign it, perfect. If the person doesn't want to sign it, the person or the company is gonna sign that he's older of 21 years old and that he turned the sum and the person didn't receive. Then you file in the court and then the person is served. If you're not allowed to serve the person, then you go through newspaper. And immigration is totally different because in immigration, normally when a person is supposed to be served in person and in paper. It's the same. Also in civil matter, you need to be served, in paper. Immigration, normally when you deal with immigration process, yeah, DHS is gonna issue, NTA, which is notice to appear. That's the summon to appear in court in front of the judge on in X day. Normally, we can attack, the summon or the NTA if there is some mistake, in the NTA. But normally, they are, surrendered or delivered in person.
Okay, thank you. And in Italy and in UK, Alberto.
In Italy, they are trying to implement more and more digitalized service systems. Since a few years ago, also us lawyers, first through some specific authorization that the Lawyers Association had to issue, we started doing formal service ourselves. We could do it directly, not in all cases, but in most cases. And since a few years, we can do it through certified email that I mentioned before, because that has the same effect as a letter with return receipt. So someone signing for the receipt of the letter. So if you have a certified email address and I serve you the paper through the certified email address, when I have the message confirming that you received it in your mailbox, it's considered as served, whether you open it or not. But still, we have, for certain matters, we still have to go through the bailiffs, the court bailiffs, to do the service. If the person or the recipient, if it's a company, for example, they don't have a certified email address, then the service is done on paper and it can be done either by post or in person. Usually the bailiffs don't want to do it in person because they have to go out, so they try to do them by registered mail, unless they have to do it in the area where they operate within the city limits, basically. So this is the system, and they are trying to, and it's much better with the digitalized service. It's become a lot easier to serve papers.
And
A
how do you
question.
get that? Oh, yes, yes.
You
Go
know,
ahead, Carla.
what happened if you receive the summon in the spam?
No, actually, it doesn't. The certified email is a bit different from a standard email address. So it's usually there is no spam in the certified email. Usually, certified can receive only certified email messages,
I
so
got it.
it is not spam usually. Of course, there have been issues where the mailbox was full, and so the message was rejected. So what then? So there's still not a unified case law on this. People are going to the Supreme Court to ask for an interpretation because it's not clear. I must say that I haven't had it yet. Usually, companies or people that have certified email addresses keep them in working order. Also, because you don't receive that many, it's not like a normal address that you use for anything. So it is rare that it doesn't work. Although I've had a case which is interesting where a company, because companies in Italy are required by law to have a certified email address. When they register with the company's registry, they must have it. Again, in the light of the general aim at having every communication digital. And I had a company that I had to serve papers to, and they had an apparently certified email address, but when I did it, the system told me that it was not a certified email address. So I had to go to the bailiffs and have the bailiffs serve it in paper. So they were faking a certified email address.
Wow.
Yeah.
Okay, here in Venezuela, we have to do it the first time by in paper by person, but
Okay.
we have had some experience by WhatsApp and by traditional or free email like Gmail or normally Gmail, but Hotmail, whatever the people have. Um, and it's used normally in the divorce when people don't want to keep getting married. They want to dissolve their wedding union because the other people is going will want to receive the communication, so it's no problem. But it has been some cases where the other the other one doesn't want to receive the communication, so it has reached up to the Supreme Tribunal, and it says if if there is no uh, verification of the reception, you have to start again. Recently, I read a case where uh, somebody, his her lawyer, went to the minors, or we call here child and teenagers courts, not minors, child and teenagers courts, and the representative, the mother of the child, uh, was really her lawyer went to the court and says, I received the communication in Instagram, and it was an Instagram account for her business, not her personal Instagram. And the judge said, but do you receive the communication? Yes. You are here in the court? Yes. So what's the violation? No, because it was too quickly. It was too quickly. I don't want it. I don't want to be notified. I don't want to receive the notification so quickly. I want it to have some time to think about it and whatever they want. So in Colombia, perhaps they say it's your responsibility to have free of um, your email. The,
Free
what's the
space.
name? El buzón. I love
Yeah,
the word right
yeah,
now.
the mailbox.
Mailbox.
The mailbox. Yes, it's your responsibility to have it clear, to have it with capacity to receive communications. And especially for if it's the first time, we can argue about it. But if it's the continuation, if you give this address yourself and you says you can reach me by this address, and it's more understandable that it's your responsibility to have it free, or at least with a minimum amount of capacity to receive communication from the court, because you said yourself, I can be reached by this means. It's not the best solution right now, but as we don't have, at least here in Venezuela, those certified emails, at least for the judges or for the companies, or less for the people. Well, it's there are some solutions that we are thinking about. And one more question, Alberto. How anybody in I mean physical person have this certified email also?
No, not everybody has it. Usually now, all of the professionals have it, like lawyers, engineers, other professions that have a specific body that manages the profession, like would be the Solicitors Regulation Authority in England, for example, or the Ordine degli Avvocati in Italy. All of those kind of professionals have it. Companies have it. So quite a large number of people is starting to have it. The idea would be that most people sooner or later have it. In fact, now there is a specific registry where one can register his own digital address. And also, what I wanted to say, a difference between Italy and England is that in England, service is usually done on paper, by hand. That's the standard, with the service processor that does it. And but in England, getting the address of someone is not always easy, because differently from Italy, where when an individual has a residency registered in the town where he or she lives, whereas in England they don't have such a register. So you have to find that there are some directories online where other data are taken into account to understand where one is resident. But it's not always easy. So often service has to be tried a few times. It's a bit easier in Italy. So usually in Italy, for example, if one is registered as resident in a certain place, or a company has the registered office in a specific place, and they are not there, after a certain number, after a couple of tries, if they don't if they don't accept the service, it is deemed to have been served anyway, de facto, substantially.
Okay, thank you. Well, with this, we finish our first block, and let's go to the second block to finish, to close this webinar. And for this time, I would like us to talk about e-hearings. Are normally accepted, Gerardo, e-hearings? You already talked a little bit in your when you started your communication, but uh, in your experience, judges there, at least in your area of practice, prefer that the people be present in the courtroom, or they are for them is the same to have them online as well?
Well, we need to distinguish, civil matter. I will say, the preliminary hearings are, held by internet. Most of the hearing of the matter of the case, they can be, run by the attorney. Sometimes you don't have to have the judge in front of you. You can, do via WebEx. You can have a meeting in the attorney's office or the other attorney's office. We can arrange this. This is a civil matter. However, when you have trial and you need to present your case in front of the judge with the jury, that's of course that's in person. However, there are some sections in which you can request to the court, if you are not present in the country, you can appear via WebEx for a final hearing. That's it. It's like a section. However, for immigration, it's totally different. Everything is gonna depend of the judges, of the judge. Some judges prefer, to have all the hearings by webs or internet. Other judges, I will say, the old, judges, or we call it here old timers. Some judges prefer, to be present. For us, it's like a pain, to drive, from our office to downtown. We're talking about, rush hour, just 1 hour in Miami to move, from my office to downtown to have a hearing of 5 minutes. There are judges that prefer, hearings of 5 minutes, but in downtown. Other judges, they don't care. You can request it, file a motion and request it. Some judges, because we already know, they don't care. You can preserve it yourself. However, the client has to be next to you. You know, every judge, have, their trick, how to, to present the case. For that matter, we have like a cheat sheet in which you put, all the name of all judges here in Miami and all the location, and we put, this judge have this preference because we don't have like a guideline. Each judge run, his own court.
Okay, thank you very much. And there in Italy, and if you have had experience in UK, Alberto, do you think the judges prefer something, one version versus the other one, or what do you think about what has been your experience?
In Italy, they found an even better way of dealing with it. So basically, we have a pre-COVID and post-COVID system because it completely changed everything. So pre-COVID, hearings were in person, period. There wasn't another way of having a hearing. So civil matters in Italy pre-COVID, there were only in-person hearings, no other way. Then during COVID, it became impossible because everything, I mean, Italy was seriously shut during COVID. I mean, we couldn't go anywhere. We couldn't even go 200 meters from our house. Basically, we were prisoners in our own houses. So they actually put in some emergency legislation where they allowed the hearings to be by video call. And quite a few hearings in 2020 and 2021 were held by video call. And they worked actually pretty well. And also, the other solution that they found was that for hearings where only the lawyers needed to be present, so there were no parties and no witnesses, and no other specific people had to be present, no technical experts, no one else, so only the judge and the lawyers. Then the judge could decide to have the lawyers file a short written submission which would substitute the hearing. So instead of having a hearing, each lawyer would file a brief, very short written submission, and then the judge would take the matter into consideration. And since after COVID, after 2021, they decided to solidify this emergency legislation. And now, for a number of cases, this has become the norm. Like, for example, cases of recognition of Italian citizenship by bloodline. This is the typical arrangement. So the hearings are only by written submission. In England, it's a mix. So there's in civil cases hearings that are held remotely. They are permitted and actually, commonly used, particularly for case management hearings or shorter applications. Again, certain judges for more difficult or cases where the parties need to be present, they prefer in-person hearings. And I've seen that, for example, for high court judgments, it is common that the hearings are in person and not via video.
Okay, here in Venezuela, well, okay, we have normally in criminal cases, it's actually very common to use video call just by WhatsApp call also. And in matters of child and teenagers, or could be maybe in Italy and they say they are called family areas of practice. Yeah? We call here we call them here child and teenagers. protection system. They use very much video calls, normally by WhatsApp. We use very much WhatsApp here, but for the judicial system, because as I said, we don't have e-record or court record in digital ambience. In 2018, Supreme Court, Supreme Tribunal of Venezuela, create the normally by rule, I mean rule for the creation of the court record in two areas of practice: teenagers criminal responsibility and violence against women. But it hasn't been worked, it hasn't been created just by the rule of law created, not rule of law. It was a sub legal under legal regulation created by Supreme Court. It's a the Supreme Tribunal of Justice acting as a legislator. I mean, create this regulation, but it hasn't been started. We have to buy the hardware and the software to start this system. But by video call, it's very common. We also have some digital halls to make those video conference, but as maybe there is one or two in the buildings where are the courts, they have to wait for it to be free, so they use their own phones and WhatsApp to make the hearings. And something that maybe can be seen or can be somebody can think that it's not procedural law, but it is actually procedural law, because your right to get in front of a court, of a judge, depends on how are you dressed. Here, if you have some kind of dress, you cannot get into a courthouse. I mean, if you have pants or a pair of trousers or jeans that are with cuts and your skin can be seen, you cannot get in. If you're a woman and you have like a V-neck shirt or a t-shirt or a shirt that is with bottoms that it's unbuttoned and you can see a little bit of your chest, you cannot get in. I wasn't think very much about it after 2018 and 16 when I read a Harvard Review report where someone says the right to get in front of a courthouse depends on what the person that is in front of who says you get in, in front of the house, like the police of the courtroom says that can get into the courtroom. So fundamental right depends on what the guardian of the door of the courthouse says who can get in and who cannot. What is the experience in Florida, Gerardo? They are so restrictive with the thing you are wearing. You can wear whatever you want to get in a courtroom. What has been your experience?
Well, normally here, Florida immigration court and civil courts, you need to have, some decency. If you're wearing, pants, a t-shirt, I think it's fine. I never seen, any issue with the people, dressing, with a skirt or something, or with with short. Oh, I seen people, presenting court in short. They will be allowed to enter. Of course, if you are, in tank, which is, you expose your arm or something, maybe, the bailee or the security will not you allow you to enter to the building. However, I have like a funny experience, like 2 months ago, during a hearing. I have a judge that we have some experience in the past. Sometimes, I present myself, the t-shirt and the tie, the jacket, I put it back because it was kind of, we'll say it was kind of hot that day. I came out, from from the street. I present myself. Here in the office, I was only with a t-shirt, with a shirt on the tie, and the judge asked me to wear the jacket before we start the hearing. I say, really? Yes, counselor. If you want to be in front of me, you need to wear your jacket. I said, sure, Your Honor. That happened to me
Yes,
like
that
2 months ago.
also that I'm watching what that you're wearing all blue vest and tie and a shirt. I read or I listened a YouTube tutorial. I don't know, uh, attorney from the United States that says that the percentage of the winning cases were superior if you wear blue. So now that I watch you wearing all blue, I think that's true.
Well,
Alberto, yeah,
no, go ahead.
maybe. Alberto, what do you think in what you're experiencing in Italy and in UK if you have it?
It's well, with respect to the lawyer, I confirm what Gerardo said. That meaning in Italy, the judges wouldn't allow us to be before them without the shirt, the tie, and the jacket. And it's happened not to me, but a colleague of mine in Bologna in the summer where it's really hot, and he was without the jacket, and the judge made him wear the jacket before the hearing started. So I understand, and also and for the parties in general, the courts want people to be dressed at least decently. Usually, there are signs at the entrance of the courts where it says that you're not allowed with a t-shirt and shorts and no shoes. You have to have shoes, long trousers, and maybe a shirt is not necessary, but let's say that keeping your arms covered is appreciated, I would say. And in England is very similar, really. So it's a formal attire for the solicitors and the barristers, and also for the parties are required to be dressed in a decent way. So it's quite formal. I must say that in Europe, I think it's in general you're required to be quite formal when you go to court.
Thank you very much. Well, just as we are drawing to an end our seminar, our webinar, I would like you to say final words about if you can summarize your experience in e-justice or infojustice in USA and Italy and in UK. What would you say? Are you pleased with your experience in e-justice in USA, Gerardo? Do you think it could be better? And also for you, Alberto. Let's start with Gerardo.
Definitely, we need to mark, distinction before and after COVID. I would say, I love it, to be present, through, video camera, video web, because you save time, money, resources. I'm also, in this moment, client feel, more comfortable, appear, from the attorney's office. I would say that uh, in this moment, especially, immigration matters. Clients that are scared, to be in court. I think that for that reason, I think, WebEx video appearance, I think it's the future. However, some judges, some regulators, I'm saying that probably, will disappear here in US. I would say that it's unfortunately. However, people say that you don't have the, you're supposed to have the right to to request evidence in person. However, I think the convenience of video appearance is amazing, and the resources are on the way that you can uh, you can access and to do everything faster is amazing. However, sometimes you have clients that don't have access to internet, they don't have how to communicate. That can be tricky for some clients to get that. For that reason, some judges require to attorneys to appear next to the clients.
Thank you very much. In your experience, Alberto, what's your opinion of your e-justice system in Italy and your experience in UK?
I think the e-justice system in Italy works pretty well compared to other aspects of public policy. That I think they have developed it quite well, and it's improved the the life for us lawyers, definitely, it's a much better system. I remember how it was before this was in place, and it was much harder. And like, because in Italy, lawyers can practice anywhere in Italy, even if they're registered with the Lawyers Association of Bologna, like in my case, I can practice before any court in Italy. And beforehand, it was very difficult because, of course, I can't go to Sicily for any case that I have, which is far away. Whereas now, I can easily manage cases in Sicily or any other region, even if it's far away. So I think it's improved the system a lot. There are some critical aspects as well, I think, because doing everything remotely sometimes makes it more difficult to make a compelling case for the judge and make the judge really understand certain finesse things in the case, I think. So I find that can be challenging, but overall it's surely improved the system a lot. And also in England, I feel that with the possibility of filing cases online, having hearings online, it's surely made the system a lot quicker and easier to access and more accessible also to lawyers, which have all the files of the case in one place, and you don't have to scramble through the paper versions every time. So definitely a positive.
Yes, I dream. I have been dreaming about e-justice. At least I started writing about it in 2012, and since then I have been presenting different proposals of regulations to have it here. But first, we have to make it the people know it. Then, when the people, everybody knows it, uh, somebody would want it, and and this somebody have to be someone with power to have this to make these decisions, and also it has to be the economy, the situation, the economical situation has to be prepared to implement and the constant actualizations of this hardware and software, because it's not a one moment inversion. There's a constantly inversion. And if we think about the big companies, the big tech companies, we are talking about billions of dollars. But I know that we don't need always like the first standard, or we don't have to be in the avant-garde, the first row in the innovation for the judicial system, but we can have some steps, as we are watching in the countries from you're talking about, that we don't we can do things with small things, and we can progress, as happens in Italy with a criminal system that is not completely
No.
digitalized. Well, thank you very much, Alberto. Thank you very much, Gerardo. This is a presentation for explain why it's important to learn another language, and this is a requirement for get into the postgraduate area of the Central University of Venezuela. Recently, when we called for the new uh, people that is getting that wants to get into the programs, and somebody write me by Instagram saying, why is it necessary to speak another language? That's against the constitution. I speak Spanish. I have to be able to study if I'm speaking Spanish. And we said, yes, it's you have the right to study in your language. That's okay. But I think that you should understand that if you speak another language, if you at least you can read another language, you will have access to another information that is not always written in Spanish. So it was a pleasure to be here with you. And I don't know if Jose Montesinos would like to have some words, have some questions. And if it's the case, you can do it by the chat. And if not, you can do it speaking by the phone. And if you prefer to keep the things like this, we thank you for being here with us. This presentation, this webinar, is disposable. Is available. Available is the word. I made the wrong translation. Is available for everybody in YouTube. So we'll keep in touch to get together in another occasion. Thank you very much.
Thank you very much.
It's our
Bye bye.
pleasure. Have a good day,
Thank
guys.
you. You too.